Imagine walking home from the store or heading to your car after work. You haven't broken a single law. You're carrying a firearm legally for your own protection and your family's. Then a patrol car pulls up. An officer steps out and tells you to stop. You're being detained because he spotted a bulge under your jacket or a holster on your belt. You're being stopped for doing something the law says you're allowed to do. For generations across huge parts of this country, that scene was completely legal. Simply carrying a gun, even with every permit in order, could give an officer all the justification he needed to stop you, pat you down, and possibly arrest you. That has changed. A major shift has swept through American law, rewriting what police can and can't do when they spot a firearm. So here's the real question. If this happened to you tomorrow, would you know your rights? Sit with that for a second. What would you do if you were stopped, not for speeding, not for matching a suspect's description, but purely because an officer saw a gun while you knew you were fully within your rights? Drop a comment and tell us how you'd react. And if you've ever felt singled out by police for exercising a right, the Second Amendment or otherwise, we want to hear that story too. Today, we're breaking down a landmark legal shift that answers this exact question with more clarity than ever before. This isn't a minor policy tweak, it's a genuine recalibration of constitutional law, and it touches everyone. To understand how big this shift is, we need to rewind to 1968 and the Supreme Court case Terry versus Ohio, the origin of modern stop and frisk law. That ruling carved out a major exception to the Fourth Amendment's usual demand for probable cause, letting an officer briefly stop and pat someone down if there was reasonable suspicion a crime was happening and the person might be armed and dangerous. It was meant to be a low bar, a fast, practical tool for checking out potentially dangerous situations. For over 50 years, that standard has sat at the center of criminal procedure, and it's been endlessly controversial. The core problem is that reasonable suspicion is deeply subjective. Courts have let officers point to almost anything as justification, being in a so-called high crime area, a sudden movement, seeming nervous. Even the original Terry dissent warned that giving police more discretion than a judge amounts to a step toward authoritarian overreach. For many communities, especially minority communities, this vague standard has turned routine stops into tools for harassment. That's the backdrop here. In many states, simply carrying a firearm, especially concealed, was treated as inherently suspicious. New York required applicants to prove proper cause, which courts read as needing a special individual need for self-protection. That effectively turned public carry into a privilege for the few rather than a right for everyone. If an officer found a gun on someone, the default assumption was often that a crime was underway. Then, in 2022, the Supreme Court's decision in New York State Rifle and Pistol Association versus Bruin changed everything. The court struck down New York's proper cause rule, ruling it unconstitutionally blocked ordinary citizens from carrying a handgun in public for self-defense. The justices declared that the right to carry a handgun outside the home for self-defense is protected under the Second Amendment. Bruin also set a new test for gun laws. Any regulation must match the nation's historical tradition of firearm regulation. If the Second Amendment's text covers the conduct and the court made clear public carry is covered, the government must prove its restriction has a genuine historical parallel. That rejected the balancing test many lower courts had relied on. Bruin's message was blunt. If the right is in the text, it's presumed protected unless the government finds real historical precedent. In the aftermath, the legal ground shifted dramatically in every state that had treated gun carrying as presumptively criminal. Courts everywhere have wrestled with an uncomfortable question ever since. If the Second Amendment guarantees the right to carry in public, how can carrying alone still be treated as a crime or justify a stop in the first place? That tension sits at the heart of a major 2025 Fifth Circuit ruling, United States versus Wilson. The court held that suspicion based solely on someone carrying a concealed firearm, a presumptively lawful act, cannot by itself justify a stop. Officers need something more. an articulable reason to believe an actual crime is in progress. The court warned that treating gun possession as automatically suspicious would deepen the link between these stops and racially biased policing. This is a massive departure from states like Iowa, where courts once reasoned that because carrying concealed was presumptively illegal and a permit only served as an affirmative defense, an officer could suspect a crime just by spotting a weapon. Wilson flatly rejects that logic in the post-Bruin world, and the ruling we're covering builds directly on it. Simply carrying a firearm with nothing else suspicious is no longer enough to justify a stop. Take a Maryland case where an appellate court ruled police can't stop and search someone solely for carrying a firearm. The case centered on Stephen Hicks, a licensed gun owner stopped by a Baltimore detective who claimed he noticed the gun's outline through his shirt. The court ruled the stop unconstitutional, since officers acted solely on possession without any suspicion the gun itself was illegal or tied to other criminal activity. For law-abiding citizens, the impact is huge. Officers can no longer use the mere presence of a firearm as an excuse to stop, question, and search you. Now they need some specific, articulable fact beyond the gun itself, pointing to actual criminal activity. That doesn't make you untouchable. A credible tip about someone carrying illegally, behavior consistent with a robbery, or being in an area where shots were just reported can still justify a stop. But the presence of a firearm alone no longer qualifies. Police aren't powerless, though. In United States versus Davis out of Michigan, officers spotted a bulge in a man's pocket from about 60 feet away and suspected it was a firearm. When they asked about a concealed license, he stayed silent, and then they noticed a magazine sticking out of his pocket. Only then did they detain him. The court upheld the stop, but not on the gun alone. It combined the visible bulge, his silence, and the fact that carrying concealed without a license was a felony in Michigan at the time. Compare that to Hicks in Maryland, where a license is now the expected norm rather than a special exception. So a gun alone no longer implies criminal activity. That tension between rulings like Wilson and Hicks will likely keep playing out in courtrooms for years, especially in states like New York that still maintain restrictive licensing. This shift reaches beyond street encounters too. Consider a traffic stop. If an officer pulls you over for a broken taillight and sees a firearm on the seat, that alone can't expand the stop into a broader investigation without independent justification. And remember, the exclusionary rule requires courts to toss evidence gathered through unconstitutional searches. So if police stop you purely for carrying a gun and then find something else, that evidence could be thrown out entirely. Real pressure for departments to retrain their officers. At its core, this is all a direct application of Bruin's historical test. The government must justify any firearm regulation by showing it matches historical tradition. Founding-era laws often regulated how someone carried a weapon, but didn't broadly ban public carry for self-defense. So a modern law letting police stop you simply for carrying doesn't have a real historical counterpart. So what should you actually do? First, know your rights. You can remain silent, and you don't have to answer questions about carrying or licensing beyond what your state specifically requires. Second, understand you're not immune from all police interaction. An officer can still stop you for a specific, articulable reason, like a reliable tip or a matching description, but a vague, anonymous tip about a gun alone isn't enough. As the Supreme Court made clear in Florida versus JL 3rd, this shift doesn't touch sensitive places like schools or government buildings, where police likely still have broad authority to stop you over a visible firearm, but on the street, in a store, or in a park, the rules have genuinely changed. Before we close, a quick note. This video is for educational purposes only and isn't legal advice. Laws vary by state, and this area keeps evolving, so talk to a licensed attorney in your jurisdiction about your specific situation. If this helped you understand where your rights actually stand, subscribe so you don't miss the next deep dive. Drop a like and tell us in the comments, have you ever been stopped simply for exercising a right you knew you had? We read every comment, and this conversation is far from over.